Good afternoon. This is House Commerce and Economic Development. Today is Thursday, February 5th. It's 2:13 in the afternoon. We are changing topics and working on H 385, an act relating to remedies and protections for victims of coerced debt. Chris Curtis from the AG's office is going to start us off because he has time constraints. And then we will have a full walkthrough of the updated strike on.
Well, thank you, Madam Vice Chair. Thank you, members of the committee, for inviting me back to testify today. For the record, my name is Christopher Curtis. I'm an Assistant Attorney General for the state of Vermont. I'm the Director of the Consumer Assistance Program, which is where your constituents call if they have questions, concerns, problems with consumer matters. So this bill is very germane to the kind of work that we do and the kinds of complaints that we get. I will be brief today. As the Vice Chair mentioned, I have a 2:30 that I need to get to, and I know you have a walkthrough scheduled with your legislative counsel. But I did want to thank the committee and your legislative counsel for taking into consideration some of the questions or issues that I raised in my prior testimony, one of which has to do with confidentiality of victims and ensuring that perpetrators can't essentially start pursuing various state agencies to see if a complaint may have been lodged and then get information, maybe even location information of the victim, or information about their financial circumstances, for example, or even just information to find out if they made a complaint and then might retaliate for having made that complaint. So there is a provision, as I understand it, in the bill that you will be walking through today that addresses that concern, that makes it very clear that for those victims that are contacting state agencies about coerced debt, those victims would have their information be kept confidential, exempt from the Public Records Act. So I think that addresses the concern from our office's perspective and probably from other state agencies that might have that kind of sensitive information provided to them for that narrow set of consumers that this affects. Secondly, I wanted to address and thank the committee for looking at rulemaking. As you will recall, Section 2 had a mandatory provision to implement rules by January of 2027, even though the effective date won't be until 2028. So that has been addressed through the sort of more standard, broader, frankly, consumer protection rulemaking provision that is in many consumer protection statutes throughout the Green Books, which basically just says, the Attorney General may promulgate rules because this is a consumer statute and we have that rulemaking authority. So that just means that if there's really no conflict and there's nothing to do, we're not required to do something and go through that exercise. Obviously, the debt collection rules will remain in force and effect regardless of the statute, but you do have some nice protective provisions in the statute that will help these victims or coerced debtors regardless. So statute always supersedes the rule. So to the extent that you're putting new protections in place, those will control. And in the event that a creditor determines that perhaps this person does not qualify for these protections, and if that's verified, they will still have that panoply of protections and rights that are set out through federal protections in the Fair Debt Collection Practices Act and under Vermont rule in CP 104. So just wanted to offer you that reassurance. I think that's good. And then we'll have rulemaking authority if, in fact, there turns out there's something that we need to do to take action and amend those debt collection rules. So thank you for that. Those are really the two main concerns that I wanted to flag and just acknowledge the committee's work on. I did want to mention too, and I think you'll hear from our sister agency at DFR a little later on, that I believe the committee is considering providing authority to one of our agencies or both of our agencies to look at coming up with certain forms for the creditors. It's our judgment. We typically don't regulate financial entities or insurance entities. That tends to be the purview of the Department of Financial Regulation. So our preference would be for that agency, which is the regulatory body that works with those financial institutions, to be the one that comes up with the form. It would be more natural for those private entities to be reaching out to or contacting DFR and to have one host for all the forms so that there's not confusion about who is it that we're supposed to be dealing with here? I think a one-stop shop that actually drafts and interprets the forms and can provide those to those private parties and then answer any questions about them would be most appropriate. Of course, we defer to the will of our friends in the legislature, but it does strike me that for banking and insurance purposes or for sort of corporate purposes, DFR might be a more familiar state agency than the Attorney General's office, which tends to work more directly with the public or with consumers. So we might be getting the complaints from the victims, but we wouldn't be providing a form to the financial institutions or the creditors or so on. Like that would be unusual, at least from our perspective. So that's just something for your consideration. I'll flag. I think that may be addressed in one way, shape, or form. And you can also certainly ask the department about its position on that as well. So I hope that all makes sense. And if you have any questions for me, I'd be happy to answer those. And I can also come back or supplement my testimony by email or in writing. So.
Nobody has questions for Chris. We'll let him get to his next appointment and we'll bring Maria up. And if we have AG questions, we'll jot them down and invite you back.
All right. Thank you so much.
Thank you.
Thanks, Chris. Well, Maria?
Hello,
Hi, Maria.
how are you? Nice to be back. Maria Royal with Legislative Council. Chris just made part of my job a lot easier, but we'll address those sections when we get there. So what's on screen and posted on the webpage is a revised draft of the strike all amendment to H 385. The one thing I'm going to mention, there is a proposal to include some suspicious banking, bank hold provisions as a possible amendment or inclusion in the strike all. It's not in this draft, it's a separate document. So we'll start walking through the changes now. They're mostly highlighted in yellow, unless they're technical. And then there's one section which I can explain in a little more detail. So the first change has to do with adequate documentation, just adding the phrase at least one of the following, not wanting to discourage a debtor from submitting more than one document if that seemed appropriate and would help to make their claim a little more persuasive. Then subdivision B, replacing, there was, and so in terms of what's considered adequate documentation, subdivision B was a Federal Trade Commission identity theft report. There was some feedback that these reports are pretty easy to obtain. You just fill out the report online, print it out. So number one, they're not really verified necessarily by a governmental entity. And yeah, so I think that was part of the concern, is that that would be too easy of a document to obtain to substantiate a claim. But instead, the language reads, a copy of an official valid report filed with a federal, state, or local law enforcement agency, the filing of which subjects the person filing the report to criminal penalties for filing false information, if in fact the information in the report is false. Subdivision C is just redrafting, making it a little bit simpler. Same thing, a court order finding that the debt was coerced. No substantive change. Subdivision D, some additional qualifying language with respect to the sworn written certification from a qualified third-party professional. Goes on to say, regarding the debtor's claim of coerced debt, based on information gathered by the third party while acting in their professional capacity. So not after the fact, but that this is information that's disclosed during a professional relationship. And then this committee suggested that former subdivision D, any other document that demonstrates a person was subject to coerced debt and that supports a debtor's statement of coerced debt might be a little bit too broad. I think the proposal was to strike that provision. So then, under the definition of coerced debt, you'll see that stricken language there. So that first subdivision A, the debt was incurred as a result of that first Roman numeral 1, the result of the debtor's personal information without the debtor's knowledge, authorization, or consent. Somebody raised the concern that that's actually the definition of identity theft. It's a separate issue, and that the real issue is what's stated in what was Roman numeral 2, but now will be 1. The use or threat of force, intimidation, undue influence, fraud, deception, coercion, or other similar means against the debtor. So, and then there was a proposal discussed in this committee, I believe, about removing the economic abuse definition and inclusion in here because it's kind of subsumed by the other definitions. So not necessary. B is the same, C is the same, not a mortgage loan. Another qualification that the debt is not a commercial loan. For your consideration. And then moving on to the definition of debtor. Oh, I think that or was just the conjunction was just missing. I believe if there was any substantive change there. So then you can see former subdivision 6 definition of economic abuse is no longer needed. And then we get down to a qualified third-party professional. One technical change and one substantive change. There was a proposal to also include a court-appointed special advocate. So this would be somebody that's appointed by a judge, typically in a proceeding where there might be a abused or neglected child to represent the best interest of the child. Usually volunteer with training, sometimes used interchangeably with guardian ad litem. I don't know if there's actually, they might be there. I looked up the definition, didn't find it in Vermont laws, so I don't know if there's but we can confirm that. But a court-appointed, trained volunteer who works with abused and neglected children in court proceedings would qualify as a third-party professional. And then D had read a licensed attorney or a healthcare provider as defined in, and it's just separating the two to make it look just easier to understand. They're separate people. The statement of coerced debt. There were no changes there except under, this is a written statement that needs to be mailed to the creditor, and there's, specific requirement based on mailing through the postal service. Then it also included any other electronic submissions. And then you'll see the stricken language as well as any other written method deemed appropriate by the commissioner. So just a suggestion that the Attorney General's office has rulemaking authority. They can always add additional forms of mailing if that seems appropriate. But otherwise, the mentioned methods are broad enough. So just changing the certificate of the qualified third-party professional to kind of square up with the definitions, so you can see no longer referencing economic abuse per se, but expanding to include a vulnerable adult who was a survivor of abuse, neglect, or exploitation. So that reflects the change that you had made previously about who potential debtors are. Let's see. So, I should have highlighted on line 8 under coerced debt prohibited. So, a person shall not cause another person to incur coerced debt, and then substantiated coerced debt is not enforceable against the debtor. Substantiated is a new term. That should have been highlighted So this next section regarding the creditor's conduct, once they received statement of worth debt, was reorganized a lot. It was very confusing to kind of strike through things were moved around. So I didn't do that. And if I had had more time, I would have actually done a compare document that actually tracked the changes, which I'll still do to make sure everyone understands exactly what the changes were. So the first subsection, just so we're clear, so within 10 business days following receipt of a debtor's statement of coerced debt and adequate documentation, the creditor shall cease all collection activities and refrain from selling, assigning, transferring from consideration such debt. I just wanted to mention that there had been a provision that said seats no longer collect garnish wages, but you actually need a court order to do that. So it didn't seem, if you're in court, then you're already noticed and you're litigating this or, having a judge look at the issue. But a creditor could not simply garnish wages under their normal collection practices. But similarly, what's considered collection activities, doesn't necessarily include the creditor can't sell or assign. If they do, they have to give notice, but this basically says, don't do that for purposes of this law. And then also notify the debtor, it has ceased all collection activities, and notify any credit reporting agency to which it furnished adverse information about such debt that the debtor disputes the accuracy of the adverse information. And that's consistent with the prior language. So subsection B is just getting at if not all of the required information is provided, what's considered adequate documentation, what needs to be in the statement of course debt, or if it's provided orally and it's required to be written. This is basically just saying if that's the case and the creditor does not decide to cease such collection activities, then within 10 business days of receiving the notice of the coerced debt, the creditor shall inform the debtor that additional written information is required and this is a little bit different, shall provide the debtor with model form A1. The original language just said, shall tell the debtor everything you need to submit. And then in talking it over, some of you have a lot of information. And just to make it really clear that the debtor, in fact, receives all of the information, understands what needs to be, that they'll be given a copy of model form A1. Then within 30 days, so once you have the statement and the adequate documentation, the creditor shall complete a review of all of the information provided by the debtor and any other relevant information available to the creditor. And upon completion of the review, make a determination as to whether to accept or dispute the accuracy of the debtor's statement of course debt and notify the debtor in writing of its determination and the good faith basis for such determination. So require written notification about the determination and also a rationale that's for the decision, a good faith basis for that determination. So once that review and determination is made, then the creditor has 5 business days to either, one, if the creditor accepts the accuracy of the statement of course debt, the creditor shall then contact the consumer reporting agencies that received this adverse information and request such information be deleted from the debtor's file and credit report. Or conversely, if the creditor disputes the accuracy of the statement of course debt, and as a result will recommence collection activities against the debtor, the creditor shall provide the debtor with written notice of the debtor's, this is new, of the debtor's right to request reconsideration of the creditor's determination as provided in subsection C, which we'll get to next. So the reconsideration is new. And then also the prior draft, it wasn't really clear what happens if the creditor disputes the accuracy of the statement. whether the creditor would need to enforce in a court of law or whether the debtor would need to enforce. So most of the laws that I looked at least Connecticut, New York, and Illinois, essentially say the creditor can resume collection activities subject to unfair debt collection practices. So all of those protections would be there. But they can't garnish wages unless they go to court, or take other legal action unless they go to court. So something to consider one way or the other. It just needs to be clear what the creditor can and can't do. So then in terms of, oh, read that wrong. I said C, didn't I? Where are these? So the reconsideration. So within 30 days following the date of mailing of the creditor's determination, the debtor may request that the creditor reconsider its determination to recommence collection activities. A debtor requesting the reconsideration shall be permitted to submit additional documentation. And then within 30 days after receiving that, reviewing all of the information, including the new information submitted, shall make another determination. Any further reconsideration of the creditor's determination shall be at the discretion of the creditor. And then this, so this is all new. This was something that was in the New York law, so something to consider, but basically stating that submitting a request for reconsideration of a creditor's initial determination is not a required condition of initiating a cause of action, getting a declaratory judgment that it's course debt. So just sometimes if there's an appeal process in law, claimants are required to fully go through that appeal process, usually in administrative hearings, before they can file an action in court. And this is just saying that you don't have to go through the reconsideration request. You can just go directly to court.
The reconsideration is the reconsideration only if they have new additional information?
Not necessarily. It says they can. Presumably, maybe they want to make a stronger case, or maybe there's something that because they'll get the good faith basis for the determination. But if they think there's something in there that's overlooked or misunderstood, they can clarify. So I think they don't necessarily, but certainly if they have other supporting documents, they probably want to submit it. But. So.
Well, I think I understand where you're going. And to reconsider, you probably should have additional information to provide to get that reconsideration. But could that be something that the company could require?
So you could, so maybe it's a distinction between, so this says, including any additional adequate documentation. Maybe you could broaden that, so it's not just limited to, you have another document. Could be another rationale or other facts that were, that's up to you. If you want to broaden it or any additional information not provided or any however you think could probably.
I think we want to make sure that we're fair to both sides, that if a creditor determines that it's not course debt, I want to make sure that the debtor is not just pushing things off.
Stop tactic.
Yeah. But I want to make sure also that if they do have other information, whether it's documentation, maybe another witness, anything like that, that they have that ability to present that as well. So I want to make sure it's even on both sides. You
You want comments for later or?
No.
So,
Well, I mean, I guess
on the reconsideration.
Yeah.
Yeah, so, it's not the same subject matter, but, I'm familiar with sometimes procedures for reconsideration. And, the affected individual will, make their initial statement. And then they'll come to someone who, might know a little bit more about the subject matter. And maybe there's not additional facts, but they do a better job of relating, of talking about the situation and why it might be, a good request for reconsideration. So it might not just be the additional information. It may be, you found someone who is better articulate in terms of writing or whatever.
Yeah.
I don't know what happens here, but I know that's happened before.
But yeah, so, I mean, I agree. Can we broaden that so that? I mean, we want to make sure that people aren't gaming it
Yeah,
and that whatever they're, when they're requesting redetermination, that it's legit.
So it's pretty broad. I don't know if it's too broad for you. So when you request the reconsideration, you shall be permitted, not required, to submit additional documentation. Yeah. So. Oh, no, I thought it was including in here. Oh, no, sorry. Da, 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 da. Yeah, shall be permitted to submit. Yeah, I think it's confusing because it says the documentation, which could be considered adequate documentation, just those documents. So additional information or documentation or that would be the broadest.
Like a significant change in situation.
I don't want to get that.
If an individual does this on their own and then goes and gets more support, like, and they did it with the help of somebody who had never done it before. And it got turned down, and then they found an organization or somebody in the organization who was helping them that had actually done this before and was able to really put all the information together. This allows for that, right? So, I mean, for the most part, we're dealing with situations where people they may not have all of their stuff. They may have left someplace without all of their things. They may have, so they may have trouble, right? Like having all of the things that they need in one place. So it might be harder for them to get all of that the first time.
Yeah.
So I'm good with it being pretty broad, and I fear that we don't want this to be a delay tactic either, so.
And I think, and I might be reading it wrong, but the company has some leeway on that as well. Because you're re-reviewing something, even if it's a, additional comment on it, it doesn't necessarily mean that. Yeah, I think, I don't know if you have to have, I don't think you do need additional documentation. Or, I think. It's been part of this process before.
You're from the banks,
yeah.
the credit unions. and-
Yeah, I think that,
I think you had it right, Maria's information.
including, or an amended statement or.
I mean, you can reverse a decision by having a conversation with somebody and see. Without additional information that's coming in, just a simple conversation.
Well, subsection F, this just specifies that all communications from the creditor to a debtor under this section shall be made using only the debtor's preferred contact method And in addition, the creditor shall make every reasonable effort to use the debtor's preferred language. So not requiring the creditor to use the language, the preferred language, but putting the onus on the creditor to try to. And then what's stricken is if the creditor provides oral interpretation services or otherwise communicates with the debtor in any language other than English, the creditor's communication shall be in the debtor's preferred language orally or in writing, except as otherwise provided in the section. So kind of striking that and just saying, make every reasonable effort to use the preferred language, always use the preferred contact method.
So that could mean that the company would have to use email communication if that's what the person requires. I don't know if that's. And I can understand like a specific address, but to make it specifically email where it's not all that secure. I mean, granted, people could argue that mailing is, but I think companies would prefer to make that decision of whether email or mail. I don't know if you want to specify that. I wouldn't feel comfortable specifying that, knowing the process.
Flag it, know your words. Okay.
So, subsection G, I think there were changes here. This is just about in connection with any statements. The creditor shall not disclose the contact information the debtor provides in the statement to any other person, including perpetrator or joint account holders without the debtor's express written authorization. That's all the same, unless directed to do so by court order. And subdivision 2 is the same. This is just the creditor may request the identity and address of the perpetrator, which the debtor does not have to provide if the debtor signs a sworn statement that disclosing such information is likely to result in abuse to the debtor or to a member of the debtor's immediate family. So that's pretty consistent with what you had before. So then subsection H, this is one of the subsections Chris Curtis spoke about. So this now provides that model form A1 shall be developed by the Commissioner of Financial Regulation, posted and no longer in 12 most common languages in Vermont, instead of English and Spanish on a publicly accessible website maintained by the Department of Financial Regulation, and shall be substantially in the following form. So then just looking through the form.
Can I just make a comment?
Yeah,
We
of
heard
course.
from the department that they're working on access. They're not going to testify today probably, but they're working on getting access to more language translation. They don't have it now, but they're going to do their best with that as they go forward. But to put it in law, to require them to do something they can't do yet doesn't seem to make sense.
That makes sense.
So just in terms of the supporting document, yeah,
Can go back, yeah, just one page.
Yeah.
Page 11, I think. In the paragraph in the form, you've given this information, blah, blah, blah. If someone used your personal information without your permission, and then, didn't we exclude that from the definition of coercion?
yeah. You can give it to if you can have it to somebody use your person or. No, you're right. That gets more to the identity theft. Okay. Unless we hear otherwise, I will strike that. This also just saying for supporting documentation on page 12, please include any one of the documents below that show that the debt was taken out by someone who you were in an abusive relationship with. It's just a little bit too narrow. So striking that, so it's clear, you might not have necessarily been. So these are the documents. So these, I believe now should sync up with what the changes were in the definition of adequate documentation. So removing the identity theft report. Most of it is already pretty consistent. Includes the court-appointed special advocate. These are now qualified third-party professionals, so just including that here in the model form. So then just notification to the debtor within 30 days, notify that they'll stop, the creditor will stop attempts to collect the course debt, notifying in writing that they're stopping to collect the debt, review your claim, make a determination as to whether you should be relieved from liability for the course debt from the creditor's perspective. So whether they're gonna no longer enforce or try to collect.
That's, oh. Sorry, I think I lost my question. It'll come back.
Just contacting consumer reporting, having them remove the information from the file and credit report, because there's a consumer file and then there's the actual report that goes out, just making clear. Remove the information from both. And then this was just adding to this model form that goes out to all debtors. If you are communicating with us by email, please confirm with us by telephone our correct email address for submitting information about the debt so we can ensure a timely response. There was a concern raised by the bankers that lots of employees of banks have email addresses and just not wanting it to get lost. So some kind of just confirm that you're using the right email address so we can respond timely. So
You're confirming with the
With the bank.
financial
yes,
institution.
I have a statement.
This is your email address. This is the correct one. to use.
Yes, yeah, some way of making sure it just doesn't get lost. The concern from the creditor's perspective was they might be hit with all these violations because they just didn't realize it had come in. So some trying to tighten
So
that
it
up.
could be multiple email addresses. Want to be sure that they have the correct one. Okay. Evelyn?
I was wondering, if when this, or in the event that this goes out to the public, like, do we want to differentiate or explain to the public the difference between identity theft and coerced debt? Because I could see kind of like, I understand that there are lines to it in statute, but in practice and practicality, I could imagine a person that may be the victim of identity theft thinking that it could possibly run into this coerced debt.
I think that's why we're removing,
Well, I understand that's like in the statute, but how are we communicating that to the public?
I think that'll be the advocates are there to help and I think they'll know the difference. They can tell them where they need to go. If it's identity theft, you go to the AG. If this is coerced debt, brought to PFR.
Do you think that still applies in the event that a person's kind of handling the filing themselves?
I think if they're filing wherever they file it, so if they file this with DFR and DFR is gonna look at it and say, no, this is identity. So I think, that's the way I would look at it.
Well, I mean, you could say that, you know, you could reference if this is a, you know, this claim relates to somebody unauthorized using your information without, you know, you need to follow the identity theft or if you want to
In the
introduce
form,
in the form.
In the form, yeah, I'm just thinking for folks that are also going through like a potentially highly emotional time. Are they gonna clearly?
The DFR won't review the forms, the creditor will,
right?
and they could conceivably say this, but if they didn't, if the debtor doesn't know that that's even an option, they think, oh, I don't qualify, but you know.
I think it's a good idea. It slows the process down if they don't understand.
We're requiring a third-party professional to certify this, though. You can't really do this on your own, right? An individual needs a third party.
That's true.
Still won't hurt anything, I think, by putting it on the form. Because, I mean, they're gonna take time to fill the form out, then they've gotta find the third party. If they already know, before they fill the form out, that this is not coerced debt, it's identity theft, then they know. And maybe there's something in there that on the form that tells them where to go if it's identity theft.
Yes.
So not too many changes with respect to civil legal remedies, just tightening up the language a little bit. Specifying that if you're actually in a civil action, the creditor has the burden to disprove the debt by preponderance of the evidence, which is default standard of proof in a civil action. Again, just tightening up the language. Subsection D. Oh, okay, so the language that's added here, you can see in bold. You had civil legal remedies and then you had creditor in a separate section, but they kind of overlapped. So in this draft, what you see highlighted here came from the creditor remedies section, and now that section is deleted. So because you're kind of talking about the same thing. So nothing in this subchapter diminishes the rights of a creditor to seek payment recovery from the perpetrator. This language is modeled after what was in its own separate section, but now it's just in the general civil legal remedies section. And so a proposal, then that brings us down to the bottom of page 13, what was subsection F. These were proposed penalty provisions. So a proposal to strike those under the Consumer Protection Act. There is a private right of action. You're entitled to collect your damages. You're entitled to collect treble damages, punitive damages, as well as your attorney's fees and costs. So just defaulting to what is the existing private right of action for consumer protection violation. And then G is the final subsection that was in the standalone creditor remedies, and now it's just all, like I said, in one section of law. The creditor remedies, you can see those subsections are deleted, that whole section. So a new confidentiality provision. 3 subsections, except as otherwise expressly provided in the subchapter or required by law, any financial and personally identifying information related to a claim of coerced debt that is shared by a debtor pursuant to the provisions of this subchapter shall not be disclosed by the recipient without the express consent of the debtor. Any privileged materials, so attorney-client privilege or healthcare privilege under federal or state law that's shared by a debtor under this section shall not be disclosed unless the debtor expressly waives the privilege or the privilege is waived by an express provision of law. And then this is the subsection that gets to what Chris Curtis was talking about. Any records or information produced or acquired by a public body, which would be subject to the Public Records Act. Under the subchapter, to the extent it contains financial or personally identifiable information shall be kept confidential and exempt from public inspection copying under the Public Records Act. And then it goes on to say this exemption shall not be subject to, and I think that's the requirement that Public Records Act exemptions are reviewed every 5 years. So it's just saying you don't need to review this. And again, Chris talked about the debt collection rules. Striking this section, they already have rulemaking authority. And then finally, I think this might be the last, oh no, 2 more things. This is under the State Fair Credit Reporting Act. This is the just specifying that in this section that concerns disputed claims, also deals with coerced debt, so it doesn't get lost because it's all the way at the bottom, as it was in your prior draft, and really just trying to make the language conform with the other provisions of the subchapter. So no intention to make a substantive change. here. Change until, so then just in terms of the application, it still takes effect July 1st, 2028. Shall apply to all course debt, including course debt incurred prior to July 1st.
So a question I have is about kind of timeline. I haven't seen any references to a time period in which, so for example, if somebody is submitting for coerced debt, is there any timeline of
30 days.
30
For the
days?
creditor to review.
No, what I meant was when the, for example,
Statute of limitations.
yeah, the statute of limitations is what that's
There
the,
is a default statute of limitations. I'm not sure what it is, but that's a good point. Do you want to? You actually raised something I was thinking about. If you want, some states toll the statute of limitations while this process is happening. Right, so, I don't know if this is a six-year statute of limitations. I'd have to confirm. I just don't know. But if you want to in any way address that or toll the statute of limitations while there's a review, you can do that so that the clock doesn't run while a debtor is in the middle of this process. That's how it's come up in other states, but if there are other issues around the statute of limitations, do that.
This is gonna wind up going to judiciary, I think.
okay.
That probably should be something that we include and then they can work on. They can determine. We just went through that on the floor yesterday.
Yeah. And
It's a good point.
I mean, you can be in an abusive relationship for far longer than 6 years. I'm not saying that we shouldn't have a statute. I just something to think about.
You also may not find out about the course that for even years to come.
So I'm not a judiciary attorney, they would know this right away, but I think there's a, from the date that you became aware of, right? So, but don't trust me on that, Charlotte, but that, there might be some.
Okay. Again. I have questions about. And I think that this is just sort of broadly, maybe not related to the language, but I have questions about. I was trying to think through all the various different sorts of debt it could be and how that. The 10 days and the 30 days and kind of what are timelines that wouldn't line up to that or that would be problematic? And I mean, I think maybe be helpful to hear from like people who do debt
We
collection.
have a whole list to hear from right now.
Okay, all right, I'll back up. I got lots of questions, but maybe it's not about the language.
The only other thing I'm gonna say really quickly is I think the language could be a little bit clearer about the debtor having a cause of action, like just stating that more explicitly for declaratory judgment that it's coerced debt. It's implied. And then also some states have specify that a perpetrator is not a necessary party for a debtor or creditor trying to seek a judgment about the debt. So in other words, the debtor doesn't have to bring in the perpetrator to prove their case if it's not.
Yeah.
That's implied in ours, but not.
Not- Both of those, you could read them in the most broadest remedial sense, but I think it could just be a lot clearer, so.
Yeah, how long is the other piece? The suspicious activity?
It's so long. mean, how long would you like it to be? I could be very fast. Do you want to do a quick run through, like just to see it and get a sense of what you want to do, or do you just assume?
What is your time frame after the floor? Are you-
I'm gonna be around for a little while, so I can come back after the floor.
We have some people scheduled on this piece, but I'd really like us to at least take a look at that language. So that we see it and then we can digest it. We continue to bake this. So that we can get this out next week.
Yep.
Hopefully not. Okay, Chris?
Good afternoon, committee, Mr. Chairman, Madam Vice Chair. How are you?
Better than you. Glad to see
Well, you don't look too bad.
You're
Well,
curious.
It's a good day to sit up and take nourishment. We'll leave it at that. But I appreciate the opportunity to zoom in.
The first day?
We're happy not to see him.
Right. Well, I'm happy not to give this to you. I told my
Appreciate
wife and daughter that my grandson can't go to school anymore because that's where he got this and down 5 of his family members. So
Yeah?
always fun. Let me start with, for the record, Chris Delia, President, Vermont Bankers Association. I think this is the first time that I've testified on this issue, on this bill. So what I'd like to do is just keep it at a high level, because Maria, who was working far too late last night, sent the draft to me, and I had a chance to go through it this morning and get it out to some folks. And I'm still getting some feedback, and my commitment to you, Madam Vice Chair, is to make sure that I get that feedback wrapped up by the end of the week. And by tomorrow night or Saturday at the latest, you've got any additional comments that I've got on the bill so we can keep the process moving forward. But let me begin by saying this is really a difficult topic. Since we first learned about this back in November of 24 and engaging in conversations, we know that it's really, really difficult. And we heard that last week with some of the testimony that was provided. In particular, I'm thinking about the example that was offered by Legal Aid. And I'm sure that's just one of many tragic stories of victims that are out there in Vermont. As I was listening, 2 things came to mind. The first is I'm a father of 4 daughters who, thank God, have never found themselves in such situations. That said, they've educated me over their adult lives pertaining to some of the difficult challenges that they've faced both in social and business settings. Fortunately, no threats of violence, but difficult nonetheless. If it were threats of violence, I may not be sitting here right now. I might be sitting in a little place with 4 walls and some bars, because that would fit well with me. The second is, several decades ago, I was clerk of the works for a construction project. I will not say where, but it was involving a shelter for women experiencing domestic violence. And while I never met any of the women, I was educated by the staff of that organization on the vital work that they do to help not only the women experiencing it, but the children of women, and giving them a safe place to go. I mention these because it's been the testimony that's been presented, I want to assure you, is not falling on deaf ears. We want to find a solution to help the victims. And again, I want to say that loud and clear. We want to find a solution to help the victims. Every banker who I've spoken to is horrified by the experiences the debtors are potentially enduring or have endured. We agree that something must be done to address the financial circumstances that they find themselves in. However, during many discussions, either leading up to the study committee or even during the study committee, we were questioning whether there was any data that was pertaining to Vermont, even just an estimate, so that we could understand the scope of the problem. But to my knowledge, data was never provided, even to the study committee. And while we heard testimony last week of an analysis and circumstances in Texas, for me, that's not adequate. For my members, it's not adequate. We'd like to get a sense of how big an issue this might be in Vermont, because that's critical to knowing how this bill potentially plays out. As you've heard, Legislative Counsel, and I thank Maria very much for the work that she's done on this bill, as well as the transaction holds, provided a very nice detailed walkthrough on the changes that have been made compared to the bill that was introduced. I want to state that those changes are a big step in the right direction when it comes to providing help for the debtor, but also a more balanced approach to the financial institutions that have to respond to the claims of court's debt. That said, I'm still in the process of reviewing this latest draft, and again, plan to have comments to you, Madam Vice Chair, no later than tomorrow or Saturday. In the big picture, I just want to share what our areas of concern have been. When we look at the bill as it was going through its development, and even to some extent now, it does shift the burden of analysis to the financial institution with only the data provided by the debtor. We are only given a limited amount of time to review that data and come to a conclusion. And if the financial institution doesn't agree, we have to go to court to disprove the debtor's claim. That's an interesting concept that some of my bankers have never heard about, and some of their lawyers have not heard about. We kind of wonder how that would even be feasible, given we only have the information that the debtor has provided. Every banker that I've spoken to said, well, we probably won't deny the claim because we're subject to civil remedies or potential penalties under Title IX. And for us, the concern is that may open up the door for more fraudulent claims. Banks will be responsible for writing off losses in the case of secured assets, unsecured assets, or excuse me, in the case of secured assets, the expense of also trying to reclaim that asset. I want to stop there and say we greatly appreciate you eliminating mortgages from the draft of the bill. We greatly appreciate you dealing with the concerns we have on commercial loans. I might add one proposal there, and that's in statute. There is a definition of commercial loan, which we would suggest referencing as we did with the mortgages. But again, how is that done if the bank, so we get to trying to reclaim the asset, and the concern is how's that done if the bank isn't provided with the name of the perpetrator? Now, again, I want to acknowledge clearly we understand the risks to that debtor and to the family members, and we would not want to put them in that risk. But the challenge we face is the bill will enable us to go after, well, let's hope the bill will enable us in the end to go after the perpetrator. But if you don't know who they are, that's tough. And we're not sure from a legal perspective if they haven't signed the loan documents, if they haven't signed the contracts, a credit card application, how are they party to this contractual relationship? What gives us the legal authority to go after them? Whether that's addressed here or whether it's addressed in judiciary, that is a concern that we have. Finally, based on unknown losses or even estimates, there's concern on the part of my members that access to credit, underwriting, and the pricing of that credit is going to change in the marketplace depending on what the outcomes of the debtor's claims over time. Underwriting processes may change, cost of credit may change, because you're having to account for an unknown of who could ever determine whether the loan we're making today may be raised at some point to be coerced debt. And if we make any of those changes in the underwriting and pricing, it has to be done across the board. It has to be done in a fair way that is not in violation of fair lending practices, which we are obligated to uphold. So I want to stop there and just close with this. Again, it looks like many of the changes that you've addressed here would address some of the concerns that we have had with the draft 1.2, and we greatly appreciate it. I want to be able to continue my review, and I will get, as I did to you, the committee members, and to the chair and vice chair, kind of a page by page, line by line, if we have any additional concerns. Very quickly, if you're going to shift to transaction holds later on, let me just say that I want to thank Maria. I want to thank DFR. I want to thank Jonathan Cooper for getting us together and the work that we've done to put into that language. Having reviewed the draft that Maria made available, I think it was yesterday, that draft looks very, very good, and I think can be a very useful tool for our financial institutions, and more importantly, offer opportunities for protecting victims of scams out there in the marketplace. How it proceeds in the legislative process, leave to you, attached to this bill or another one standalone. But I just wanted to chime in and say we greatly appreciate the work that's gone on in that. And with that, I'll stop and answer any questions that you might have. And my intent is certainly to be available to you via text, email, or I will haunt you in person on Tuesday when I'm back in the State House.
Provided you're not contagious.
Yeah, I plan on it.
Oh, God.
You like your sharing, but not everything.
Yeah, thank you.
Any questions for Chris? Okay, we look forward to other edits you might have.
Yeah.
Certainly appreciate the back and forth, everyone's willingness to work together on this.
Thank you. I appreciate it as well. In particular, Madam Vice Chair, for her work on this.
Colin, I don't know that, did you want to?
I have some comments for the course that,
Okay,
but I also
Yeah.
have.
well, and we'll ask you back for because we haven't even looked at the language yet.
Thank you for allowing me to speak here. Colin Hilliard, the Advocacy Director for AARP Vermont. It's good to be back in this committee with you all. AARP is supportive of both remedies and protections for victims of course debt, and also the bank holds for suspicious activity, which you're going to hear about a little bit later. Really appreciative of this committee's work to strengthen protections for victims of exploitation. Financial exploitation is the most frequent form of elder abuse among passive neglect, willful deprivation, confinement, physical, sexual, and emotional abuse. About 1 in 10 older Americans experience some form of elder abuse, but only 1 in 24 cases of abuse are reported to authorities. Older adults are highly likely to be financially exploited by someone that they know. So from friends, family, service providers, and caregivers as well. And as a result, that can make their ability to pay for necessities such as food, rent, healthcare extremely difficult. And this can push older Americans into poverty, homelessness, and raise the likelihood that older adults are having to rely on public assistance. To speak specifically on the coerced debt provisions here, identity theft and coerced debt have been the most common types of fraud that are reported to AARP's Fraud Watch Network hotline. That's our 1-800 number. That we try and get the word out there as much as possible to senior centers around the state. We work with the Attorney General's office on that as well. And it's staffed pretty much 24/7. And we receive hundreds of thousands of calls a year from folks to that network. And coerced debt and identity theft are the top thing that they hear from folks calling it. And you don't have to be a member to call into that. That's out there for everyone. And is actually in partnership with the Colorado Attorney General's office. So coerced debt is particularly problematic for older adults whose incomes typically decrease as they leave the workforce and through retirement, disability, and medical conditions. And it greatly limits their ability to recover lost income. Or rebuild their credit scores, something that I think is really important when we talk about older folks and how they're affected by this. Broadly, we're really supportive of the direction of this bill, and still kind of digesting these latest changes. So I want to keep it pretty high level, and I know too we're coming up on the House floor, but did want to just flag for you all two areas of concern from us. And so one of those being a lot of the changes we saw on page 8, 9, and 13 around allowing creditors to determine how the debt was coerced. And so this is still kind of digesting this from our policy folks, but seems a little bit different from the intent that we initially read around, suspending liability when the debtor establishes the case with their coerced debt claim. And so having to prove that with a preponderance of evidence in court when they have, so essentially, we see this as adding a lot of confusion in the process, and I'm happy to share some language from our folks that I'm still waiting for on what we've seen in other states on how to kind of clarify that. Another section, also the exemption of debts that have already been part of a final judgment in a dissolution or collection. That's on page 2, lines 15 and 17. Certainly understand the concerns around opening up a case that has already been litigated, but we had two really clear examples that we wanted to share with and just make sure that folks understand the implications of this in some cases. So one being an older person with a diminished capacity who is being financially exploited. They don't know what to do with the notices that they've received from a collection agency. And so this becomes subject to a default judgment. And they're being exploited, but now that judgment's made, there's no recourse for them. So this bill wouldn't apply to them. Another that I wanted to touch on was, if someone is in a marriage and you're a victim of abuse, agrees to dissolution where each party is responsible for their own debts, just to get out of the marriage as quickly as possible, and a way to get to safety and whatnot. Both of these cases, as the bill's written with exempting debts that have already been part of that financial judgment, they would not have a recourse here in our reading of this. So that explicitly stating that is different from some of the model bills that we've seen and worked on in other states. So I just wanted to call that out. I think those are the two big things for us, and wanted to keep it relatively high level. Again, we are also still working through the really substantive changes in the last draft, and happy to follow up with the committee with those. And then also have a lot more on suspicious transaction holds. We were a part of the working group for that, and a lot of really good work was done, and we're really hopeful that will move in some form, whether it's this bill or another.
Questions for Colin? Great, thank you.
Thank you.
We have about 5 minutes. Grace, did you want to?
She's watching the
Is
live,
she on live?
and she was gonna jump in when it was her turn, but.
Katie?
Is Katie here?
If he's on Zoom.
I'm sorry, I couldn't hear you guys. I
Hi,
apologize.
Katie.
Hi.
We have about 5 minutes.
Okay, I'll go quick.
Thank you.
Dee McKenzie, I live in Washington County. I'm a survivor of domestic violence. I want to first thank you all for the work you are doing on H385 to give survivors of coerced debt a real path forward. It is really important. My former partner used economic abuse as a way to control me, to keep me from being able to leave safely with my 3 children. He took money from my bank account without permission, wrote bad checks in my name, stole belongings from our home, and my home.
Hi,
after
can you all hear me?
Sorry, Grace, we moved on to the next presenter.
Oh, my apologies.
That's okay. We're about out of time anyway. We'll invite you back again when we take this up next week. Go ahead, Katie.
He took the van I depended on to get my children to school and activities, and refused to return it until he totaled it. Even after I left, the financial abuse did not stop. For more than a year, he continued to stalk me and used our shared children as a way to maintain power and control over my life. He forced me to pay his household bills using my credit card when I could not afford it. When I tried to say no and stop that, he became aggressive enough that I feared for my safety. He threatened to move to New Hampshire during this time, and I understood that as a way to pressure me to continue paying. I felt like I had no choice. Leaving did not end the abuse. It just changed the form that it took. I left 4 years ago, and I'm still living with the financial consequences every single day. Over the course of this abuse, I was forced into more than $20,000 of debt. I had to take out a high interest loan simply to cover basic living expenses for me and my children. This affects my children in real ways. Their father and I agreed to split the cost of an art camp for our daughter. When he did not pay his share, I could not cover the difference. She had to leave the program. This is what economic abuse looks like years later. I now live in a 500 square foot home with my 3 children. We need more space, but I cannot qualify for a home improvement loan. I once had excellent credit, and abuse destroyed it. The impact of economic abuse goes far beyond the debt itself, and that is true for many survivors. But H385 would allow a meaningful step for people like me to rebuild stability, independence, and a safe future for our children. Thank you for taking the time to listen. If you have any questions, sorry, I had to be rushed.
Thank you, Katie. And we are certainly sorry for your experience. Any questions? Emily?
Katie, thank you very much for sharing your story. I'm Emily Harris Duncan. I represent Wilmington, Whitingham, and Halifax. And I'm so sorry to hear what you're continuing to go through. Do you have any thoughts on statute of limitations for this bill? Like, do you have any thoughts on how long? Yeah.
I mean, obviously, I won't fall under that statute if it's 6 years. I separated from my children's father in 2022, so I'm still suffering with that debt. Like I still have. I'm doing my best to overcome it, but like that's something I wouldn't be able to benefit from, and that's okay. But I worry about other people. I think the statute of limitations being, if it was 6 years, would not cover a lot of people. And there's people out there who've been through a lot worse than I have. So, yeah.
Thank you. I really appreciate that.
Questions? Katie, thank you very much. Committee that have to get to the floor, so let's back immediately after adjournment. Back in here so we can hear the second piece of this consumer protection that we're trying to do. Sooner we're in here, the sooner we're out of here. So with that, we will be back immediately after the floor concludes. So we can go offline here.